As I was driving up here this afternoon, it occurred to me that, well, you can usually choose your wedding date. You can't choose your birth date. And if you could, I expect that most people would pick June for both events if they knew they were going to take place in Warren County. But we're here, and I do appreciate the invitation to join in commemorating the birthday of Robert H. Jackson, a native son of Warren County, an adopted son of our neighboring state of New York. In 1986, Chief Justice William Rehnquist gave a talk to students at the University of Chicago Law School. The Chief Justice spoke about the role of lawyers in our country's public life, telling the students that many of America's earlier leaders were wise and public-spirited lawyers who had been regarded by their contemporaries as models to be admired and emulated. And he concluded by lamenting the demise of this important model in American politics. Professor Anthony Kronman elaborated on this theme in his superb book, The Lost Lawyer, and likewise regretting the passing of an older set of values that until fairly recently played a vital role in defining the aspirations of the American legal system. At the very center of these values, which Professor Kronman calls the ideal of the lawyer-statesman, was a belief that the outstanding lawyer, the one who serves as a model for the rest, is not simply an accomplished technician, but a person of prudence or practical wisdom as well. Earlier generations of American lawyers, wrote Professor Kronman, conceived their highest goal to be the attainment of a wisdom that lies beyond technique, a wisdom about human beings and their tangled affairs that anyone who wishes to provide real deliberative counsel must possess. The lawyer-statesman, according to Professor Kronman, understood this wisdom to be a trait of character that one acquires only by becoming a person of good judgment and not just an expert in the law. And he offered as more contemporary examples Henry Stimson, Dean Acheson, John McCloy, and Robert Jackson. Now, these men all possessed the characteristics so ably and eloquently described by Professor Kronman, and were sought out for their wise counsel. All rose to the highest levels of our national government and played a prominent role in the major political and diplomatic events of our country's mid-20th century, serving as trusted confidants and advisors to the presidents and administrations of which they served. There are, however, several notable differences in the background of these lawyer-statesmen. Henry Stimson, Dean Acheson, and John McCloy all graduated from Harvard Law School. Stimson having been educated at Phillips Academy in Andover and Yale College, Acheson at the Groton School and Yale College, and John McCloy at the Petty School and Amherst College. Robert Jackson, on the other hand, was a product of the public schools of Frewsburg and Jamestown, New York, never attended college, and was essentially self-taught in the law, having matriculated but 1 year at Albany Law School and apprenticed in his cousin's law office. Stimson and McCoy began their legal careers on Wall Street, and Acheson with a large and prominent Washington, D.C. firm, whereas Robert Jackson spent his first 20 years in the law as a county seat lawyer in general practice in rural Jamestown. It's these aspects of Justice Jackson's background which hold special resonance for those of us who were raised in small towns, educated in the public school system, and practiced law in our county seats. Of course, we know the path of Justice Jackson's career when he left his practice in Jamestown to enter government service at the request of his longtime friend, President Franklin Delano Roosevelt, General Counsel of the U.S. Treasury Department's Bureau of Internal Revenue, Assistant Attorney General in charge of the Tax Division of the Justice Department, Assistant Attorney General in charge of the Antitrust Division, Solicitor General, Attorney General, Justice of the United States Supreme Court, and America's Chief Counsel at the Nuremberg War Trials. During these years, there were very few major decisions of the Roosevelt administration in which Robert Jackson's counsel was not sought. But this evening, I would like to focus on a dilemma which presented itself to Justice Jackson toward the end of his career and his all too short life in the form of the landmark case of Brown versus Board of Education. But to place this account in perspective, I first need to say a few words about the work of constitutional interpretation and Justice Jackson's judicial philosophy. In the arena of constitutional interpretation, a court, particularly a Supreme Court, makes difficult choices among competing values. And unlike the value choices made by the political branches of our government, the executive and the legislature, courts are obliged by tradition and compelled by institutional necessity to supply reasons for such choices. The typical tools employed in constitutional interpretation are text, original understanding, precedent, and custom. Text is, of course, the language of the constitutional provision at issue. History, often referred to as original understanding, inquires into the intent of the framers in placing a certain provision in the Constitution. In other words, what meaning did a particular constitutional provision possess at the time of its drafting and ratification? But of course, the ascertainment of the original understanding of the framers is the beginning and not the end of the inquiry, for it is, after all, as Chief Justice Marshall famously said, a constitution which is being interpreted. It necessarily follows that if the meaning of our Constitution's provisions were frozen in time, in the convention summer of 1787, or the ratification year of 1788, this organic document could not have served as a viable framework for our government for 220 years without substantial amendment. Therefore, although history informs and elucidates, and thus has weight in constitutional interpretation, as Professor Alexander Bickel cogently wrote, the original understanding forms a starting link in the chain of continuity which is the source of the court's authority. What is relevant is not alone the origin of constitutional provisions, but also the line of their growth, the further links in the chain of continuity. Judges have recourse to precedent, prior decisions regarding the constitutional provision at issue. And finally, in constitutional interpretation, judges often take into account the settled customs of the people. But in addition to these legal factors, there is also a political aspect to constitutional interpretation. I use the word political not in a negative or partisan sense, but in the very real sense that considerations such as a judge's personal values, social mores, and external political pressures array themselves in this process. Now, Justice Jackson was certainly no stranger to politics of the partisan variety. As Professor John Barrett recently reminded us in one of his periodic Jackson List posts, Robert Jackson was interested in and connected with Democratic politics for his entire life. In his youth, he spoke and worked in Chautauqua County for presidential candidate Woodrow Wilson, and later served for a time as county chairman. He became active in New York State Democratic politics and worked actively for Franklin Roosevelt's elections as New York governor in 1928 and 1930, and his presidential elections in 1932 and thereafter. During Jackson's Washington service in the Roosevelt administration, he interacted with and befriended the politicians involved in the national government, although he, of course, ultimately decided against seeking elective office himself. Aside from Democratic politics, however, Jackson was a student of the American constitutional system, serving as he did in both the executive and judicial branches. He was well schooled in the design of the framers and believed strongly in the necessary separation of power and responsibility among the three departments of government. Jackson understood politics in yet a third sense. Based upon his life's experiences, foremost his many years of practice in the county seat of Jamestown, he had acquired, as Professor Kronman put it, a wisdom about human beings in their tangled affairs. As Jackson said in his famous ode to the county seat lawyer, such a man understands the structure of society and how its groups interlock and interact, because he lives in a community so small that he can keep it all in view. On July 11th, 1941, Robert Jackson was sworn in as an Associate Justice of the United States Supreme Court, on which he served until his death in 1954, except for the leave of absence to represent the United States at the International Military Tribunal in Nuremberg. During his tenure on the court, he settled into an approach to judging which legal academics would describe as one of judicial restraint, a philosophy which was most aligned with that of his closest friend and colleague on the court, Justice Felix Frankfurter. Justice Jackson envisioned a limited role for the court in resolving the claims of aggrieved parties, believing that in a democracy, civil liberties could truly be protected only by the will of the people and not by 9 appointed judges. He espoused a vision of federalism that weighed heavily on the side of state prerogatives. He tended to protect the rights of the community against the constitutional claims of disaffected individuals. Although Justice Jackson referred to the Constitution as a blueprint, a foundation upon which the constitutional structure is to be built to meet the exigencies of the times, he had a great respect for the weight of precedent and the role of stare decisis in terms of the settled expectations of the people, and he thus generally disfavored overruling precedent. He understood the enforcement limitations of the judicial branch, mirroring Alexander Hamilton's oft-quoted passage from the Federalist number 78, in which Hamilton wrote that the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them, as the judiciary has no influence over either the sword or the purse, and thus may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Justice Jackson was wary of judicial supremacy, not only because he thought it inconsistent with democracy, but because he felt that unenforceable judicial decrees bred public cynicism. Finally, Jackson, like Frankfurter, thought that judges were obliged to separate their personal views from the law. So let's come now to the Brown case. Brown versus Board of Education was argued twice on the merits, first in the 1952 term of the Supreme Court and again in 1953. In accordance with the court's practices, conferences were held following both arguments. Although the men in the room at both conferences are long since dead, several of the justices took notes which survive, and scholars have attempted to reconstruct the deliberations which took place, among the most notable being Professor Michael Klarman in his award-winning book, From Jim Crow to Civil Rights. The first Brown Conference was held on December 13, 1952, a few days after the argument in the case had concluded. Chief Justice Fred Vinson began the discussion, as the Chief Justice traditionally does, and spoke in favor of affirming the lower court decisions upholding the constitutionality of segregation. As was also tradition, the justices then proceeded with their remarks in order of seniority. When Justice Jackson's turn came, he had admitted that his upbringing in rural New York had afforded him what he called little experience or first-hand knowledge by which to test many of the arguments advanced in these cases. He was not, he said, conscious of the race problem until he moved to Washington, D.C. in the 1930s to join the Roosevelt administration. He found nothing in the history of the 14th Amendment or the precedent of the court which would say that public school segregation is unconstitutional. He also asserted that the NCAA's brief, filed by its counsel Thurgood Marshall, was predicated on sociology and not law. He predicted that segregation was nearing an end and expressed the hope that Congress would act to end the practice, obviously alluding to the enforcement clause of the 14th Amendment. The first conference was inconclusive, as no clear majority emerged, and it was decided to set the case down for re-argument the following term. Justice Jackson suggested, and the court agreed, that the Attorney General of the United States be formally invited to appear as amicus at the re-argument and to file a new brief. In setting down the case for re-argument, the court propounded a series of 5 questions to the litigants, 2 of which inquired into the original understanding of the framers and ratifiers of the 14th Amendment. The scholarly consensus, based on the notes of some of the justices, was that at the conclusion of the first conference, there were only 4 solid votes for declaring a segregation in the public schools unconstitutional. Those 4 being Justices Douglas, Black, Burton, and Minton. Although Justice Frankfurter had indicated his willingness to outlaw segregation in the District of Columbia's public schools under the Due Process Clause of the Fifth Amendment. Chief Justice Vinson died in September 1953, and President Eisenhower replaced him with Earl Warren, the governor of California, who, as the new Chief Justice, presided over the December 1953 conference following re-argument. Opening the conference, the new Chief Justice left no doubt that in his view, the separate but equal rationale was no longer sustainable. With this expression, the outcome in Brown was no longer in doubt, since there were now 5 votes for overruling Plessy, which had announced the separate but equal doctrine. Professor Bernard Schwartz has described Jackson's presentation at the second conference. Jackson started his conference presentation by noting that Cardozo said the work of this court is partly statutory construction and partly politics. This is a question of politics, said Jackson. Now, what Jackson meant by this is clear from his other writings, in which he said, of course, Cardozo used politics in no sense of partisanship, but in the sense of policymaking. In this sense, Jackson told his colleagues, a decision against segregation would be a political decision, since the segregation issue is, or was to him, a question of politics. Justice Jackson also said that the decision, for me personally, is not a problem, but it is difficult to make it other than a political decision. Our problem is to make a judicial decision out of a political conclusion and define a judicial basis for a congenial political conclusion. The clear implication was that he, Justice Jackson, would support a properly written decision striking down segregation. Justice Jackson's struggle in Brown is most distinctly expressed in the draft concurrence which he prepared. I have a copy with me. This draft went through several iterations, and the latest, and presumably final, was dated March 15th, 1954. In part one of the draft concurrence, Jackson invoked his own education in an integrated school where he said Negro pupils were very few, as predisposing him to end segregation. But he immediately disassociated the personal from the legal. Decision of these cases would be simple, Jackson said, if our personal opinion that school desegregation is morally, economically, or politically indefensible made it legally so. Jackson saw segregation as rooted in social custom and in the politics of Reconstruction. Its removal would mean, he said, nothing less than a substantial reconstruction of legal institutions and society. Although he doubted the court's power to effect such a drastic change by its decision, he believed that non-judicial forces would eventually accomplish the same result. The issue for Jackson thus had two distinct components: whether the law supported a decision declaring segregated education unconstitutional, and whether such a decision fell within limitations on responsible use of judicial power in a federal system. In his draft, Justice Jackson ultimately answered both questions in the affirmative, but only after establishing the difficulties attendant on that outcome. In the final section of the draft, Jackson relied on what he termed the dramatic change in the condition of the black race, together with the effects of racial assimilation and the transformation of education from a privilege for the few to a statutorily enforced right as the basis for invalidating segregation. It was, Jackson concluded, neither novel nor radical doctrine that statutes once held constitutional may become invalid by reason of changing conditions. He remained, however, cautious about the extent of the court's role in imposing a new order, and concluded this section by calling for re-argument on the nature of the appropriate decree. The court actually adopted this suggestion at the final Brown conference, in which Justice Jackson participated on January 16, 1954, determining to set Brown down for yet a third argument limited to the issue of the appropriate remedy. The draft concurrence was never circulated to the court, perhaps because Justice Jackson suffered a heart attack 2 weeks after the final draft and was admitted to Doctors Hospital in Washington, D.C., where he remained as a patient from March 30th to May 17th, 1954, the date on which the Brown decision was announced. He did, however, discuss the draft as well as the main opinion of Chief Justice Warren with the Chief Justice who visited him in the hospital on several occasions during his stay, including the morning of the Brown decision. Chief Justice came to the hospital that morning. To Chief Justice Warren's consternation, that morning, May 17th, Justice Jackson insisted on going from his hospital bed to the court in order to be on the bench when the decision was announced. And of course, the concurring opinion was never filed, inasmuch as the decision was unanimous. There's little doubt that the Chief Justice urged Justice Jackson not to issue any concurrence which would detract from the force of a unanimous opinion. And Professor Schwartz speculates that Jackson's weakened physical condition prevented him from doing the work required to convert his draft concurrence into a finished concurring opinion. But I personally find it equally plausible that Justice Jackson, based on everything we know about him, understood at the end the necessity of the court speaking with one voice on an issue certain to have such profound consequences for the social and political systems of the United States, and so put aside any reservations he might have had with the opinion's articulation of the constitutional principle at stake. Although it is clear that the final opinion incorporated at least one of his suggestions. And so, in sum, throughout the Brown arguments and conferences, Justice Jackson was concerned with the question of how a proper opinion striking down segregation could be written, and was equally troubled by the issue of how such a decision could be enforced. Professor Laura Ray has distilled his dilemma. Jackson's performance in the Brown saga reveals with unusual clarity a justice struggling to reconcile his political and judicial divisions. Privately convinced of the rightness of desegregation, Jackson worked to ground the court's result not in his own policy preference, but in the terra firma of legal doctrine. So let's look now at the opinion itself. Many of you have read it. Perhaps it's been quite a few years ago. So let me take you through the opinion. The history of the adoption of the 14th Amendment, to which re-argument had been largely addressed, although casting some light, was the Chief Justice Warren, writing for a unanimous court, was, the Chief Justice said, inconclusive at best. The most avid proponents of the post-war amendments, by that meaning the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, undoubtedly intended them to remove all legal distinctions among all persons born or naturalized in the United States. Their opponents, just as certainly, were antagonistic to both the letter and the spirit of the amendments, and wished them to have the most limited effect. What others in Congress and the state legislatures had in mind cannot be determined with any degree of certainty. Having found history inconclusive on the question before it, the court turned to its precedent, to its earliest decisions concerning the Reconstruction Amendments, the Slaughterhouse cases of 1873 and Strotter, West Virginia, decided in 1880, which proscribed, the court said, all state-imposed discriminations against the Negro race. The Slaughterhouse cases having stated that what we do say and what we wish to be understood is that in any fair and just construction of any section or phrase of these amendments, the Reconstruction Amendments, it is necessary to look at the purpose, which we have said was the pervading spirit of them all, the evil which they were designed to remedy, and the process of continued addition to the Constitution, until that purpose was supposed to be accomplished, as far as constitutional law can accomplish it. The court noted that the separate but equal doctrine did not make its way into the court's jurisprudence until 1896 in the case of Plessy versus Ferguson, which involved transportation and not education. Here, however, the court was presented with findings of the trial courts that the schools involved had been equalized or were being equalized with respect to buildings, curricula, qualifications, and salaries of teachers, and what the court called other tangible factors. Thus, the court said its decision could not turn merely on a comparison of such factors, but rather that it must look instead to the effect of segregation itself on public education. In doing so, the court said, importantly, we cannot turn the clock back to 1868 when the amendment was adopted, the 14th Amendment, or even to 1896 when Plessy versus Ferguson was written. We must consider public education in the light of its full development and the present place in American life throughout the nation. Only in this way can it be determined if segregation in public schools deprives these plaintiffs of the equal protection of the laws. It was with this understanding that the court turned to the constitutionality of public school segregation and reasoned that to separate black school children from others of similar age and qualification solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. And because the policy of separating the races is usually interpreted as denoting the inferiority of the black group, the court held that segregated educational facilities are inherently unequal and violate the Equal Protection Clause. So, the opinion was brief, 5 pages in length, and decidedly minimalist, which is understandable given the desire of the voice of the court to speak in one voice. 9 justices, unanimous. Since Justice Jackson died on October 9th, 1954, he did not live to observe the aftermath of Brown. The decision was met with fierce resistance of every imaginable variety in most parts of the South. Public schools were closed, political careers of moderate Democrats were ended, and federal judges were threatened. Eventually, however, the political branches became involved, as Justice Jackson foresaw they must if the decree was to be effectuous. President Eisenhower ordered federal troops to Little Rock in September of 1957 to enforce the segregation of the schools, public schools, and Congress passed the landmark Civil Rights Act of 1964, which extended voting rights and outlawed racial segregation in schools, at the workplace, and in public accommodations. In his draft concurring opinion, Justice Jackson had predicted 2 generations of litigation. And as it turned out, that prediction was overly optimistic. As recently as 2007, the Roberts Court decided a case involving school districts' use of race in public pupil assignment plans. But now, to the final chapter of the story. The legacy of Brown in our constitutional landscape. Judge Robert Bork, a conservative legal scholar, has noted that any constitutional theory that seeks acceptance must, as a matter of psychological fact, if not of logical necessity, account for the result in Brown. But this was not always the case. Many, particularly in the South, felt that the decision was simply wrong. But as we know, criticism which merely attacks the outcome of a case is not legitimate. To be valid, a criticism must demonstrate why the result is unsupportable as a matter of constitutional interpretation. Critique from the Legal Academy was, of course, more directed. Some said that the opinion was grounded on pseudoscience, psychological studies purporting to demonstrate the adverse effects of enforced segregation. And it is true that the court cited several psychological treatises in a footnote. And recall that Jackson had said that Marshall's brief began and ended with sociology. But the main critique came to the fore in Professor Herbert Wechsler's seminal article on neutral principles of constitutional law. After laying out and supporting the thesis that constitutional interpretation must be principled and neutral in its application, he illustrated with a number of examples culminating with the segregation cases. Professor Wechsler said, to loosely paraphrase, that as much as he applauded the outcome of Brown, he was simply unable to discern a neutral principle on which the decision rested. Rejoinders followed, and by far the most eloquent was that of Professor Charles Black of Yale in his 1960 article, The Lawfulness of the Segregation Decisions. Professor Black acknowledged at the outset that if the cases outlawing segregation were wrongly decided, they should be overruled, but undertook in succinct fashion to demonstrate why they were rightly decided by what he called the overwhelming weight of reason. The basic scheme of reasoning on which these cases can be justified, he said, is awkwardly simple. First, the Equal Protection Clause of the 14th Amendment must be read in its historical setting to say that the black race as such is not to be significantly disadvantaged by the laws of the state. That is, it is to enjoy equal protection of the laws. Secondly, segregation is a massive intentional disadvantage of the black race as such by state law. He rested the proof of his first premise on precedent, again the slaughterhouse cases in Strotter versus West Virginia. Professor Black pointed out that the Plessy Court did not deny the slaughterhouse and Strotter principle, but merely sought to show that segregation did not really disadvantage the black race, and thus that the 14th Amendment could be accommodated by providing equal, albeit separate, facilities. As to his second premise, that segregation offends against equality, he recounted in vivid detail the history and effects of segregation in the South, where he was born and raised, asserting that all of this was a matter of common knowledge. Coming to the central issue, though, namely, how is a court, in its decisional capacity, to take account of this history? Professor Black provides the following answer. I have stated these points shortly because they are matters of common notoriety. Matters not so much for judicial notice as for the background knowledge of educated men who live in the world. A court may advise itself of them as it advises itself of the facts that we are a religious people, that the country is more industrialized than in Jefferson's day, that children are the natural objects of a father's bounty, that criminal sanctions are commonly thought to deter, that steel is a basic commodity in our economy, that the imputation of unchastity is harmful to a woman. Such judgments made on such a basement are the foundations of all law, decisional as well as statutory. It would be the most unneutral of principles, improvised ad hoc, to require that a court faced with the present problem refuse to note a plain fact about the society of the United States. The fact that the social meaning of segregation is the putting of the black in a position of walled-off inferiority, or the other equally plain fact that such treatment is hurtful to human beings. The case seems so one-sided that it is hard to make out what is being protested against when it is asked rhetorically. how the court can possibly advise itself of the real character of the segregation system. It seems that what is being said is that while no actual doubt exists as to what segregation is for and what kind of societal pattern it supports and implements, there is no ritually sanctioned way in which the court, as a court, can permissibly learn what is obvious to everyone else and to the justices as individuals. But surely, confronted with such a problem, legal acumen has only one proper task, that of developing ways to make it permissible for the court to use what it knows. Any other counsel is of despair. It is my sense that Justice Jackson would have been pleased with Professor Black's distillation of the prudential underpinnings of Brown. But I also believe that were he with us this evening, he would readily agree that the conflict which he experienced in Brown was well captured by his friend, Felix Frankfurter. Judges, wrote Justice Frankfurter, are called upon for allegiance to nothing except the effort, amid tangled words and limited insights, to find the path through precedent, through policy, through history, to the best judgment that fallible creatures can reach in the most difficult of all tasks, the achievement of justice between man and man, between man and state, through reason called law.
Maybe we have time for a few questions, but before that I want to be sure that it's something very special that we want to give to you. This is the first biography, and up until Gail Giro's, by Eugene Gerhardt. And we had this reprinted, and he signed a few of these before he passed away just a year or so ago. But I want to make sure we present one to you.
I treasure that. Thank you.
Thank you very much.